If you think getting your trademark application approved is all you have to do to protect your brand, think again. Trademark rights can be lost. So getting your trademark application approved is just step one on an ongoing brand protection journey. You need to keep at least 3 other things on your trademark to-do list at all times. Hey friends, welcome back to my YouTube channel. I'm so happy you're joining me today. I'm Faith Mitton, a trademark attorney on a mission to simplify trademark law for entrepreneurs and business owners so that they can understand their legal rights better. Here you will find tons of content to help you learn how to navigate the crazy world of trademarks and stay on the right side of the law. Today, let's explore life after your trademark has been officially registered. Because once your trademark application is approved, or in other words, your trademark is officially registered, it's time to do a happy dance and celebrate because that is a huge accomplishment. It takes months, sometimes years to get through this process, and many people do not successfully make it to the other side. And although it's important to acknowledge this victory, it's also important not to rest on your laurels, because getting the trademark registration is only part of the picture when it comes to protecting your brand. The other part is maintaining these rights because they can be lost. It all boils down to monitoring your trademarks to detect and address infringement, using your trademarks correctly, and keeping your registration active. Let's take each of those one at a time. First up, trademark monitoring is key to ensuring that you do not lose your trademark rights. It's a common misconception that once you have the trademark registration, you're automatically protected from infringement. That is not the case. The responsibility to protect your trademark registration once it's granted falls squarely on you, and not finding and dealing with potential threats to your brand can cause you to lose the trademark rights that you fought so hard to get. So one more time for people in the back, the government is not responsible for enforcing your trademark rights. Although the USPTO does try to prevent confusingly similar trademarks from being approved, they don't always get it right, and some things can slip through. So you don't want to rely on the USPTO to catch every trademark conflict. Plus, the USPTO can only make decisions about pending applications. It can't do anything about trademark conflicts that happen outside of the application process. This is why monitoring your own trademarks to find trademark conflicts is important. If you have a trademark registration that grants you exclusive rights to use your brand, the only way to keep the spotlight on your business is to prevent anyone else from stepping into your spotlight and diluting your uniqueness. So as part of protecting your brand's uniqueness, your job is to be on the lookout for confusingly similar trademarks. And a trademark attorney can help you do the kind of monitoring to detect these kinds of trademarks. But the real value of having an attorney help you with your trademark monitoring is figuring out what to do when you detect what could be infringement. Because rushing in to take action against someone who actually has stronger rights than you can backfire big time. And let's be clear, just getting the trademark registration approved before somebody else does not mean that you have stronger rights than them. The strength of trademark rights depends at least partially on who began using the trademark in more than one state first, with the strongest rights going to the earliest user. So someone who has stronger rights than you may be able to cancel your trademark registration and invalidate your trademark rights if they can prove that they began using the trademark in more than one state earlier than you did. But ignoring that for a second, assuming that you do have stronger rights than someone who was infringing on your brand, then you actually have to take action to stop the infringement. And there are a bunch of different options for this. You could send them a cease and desist letter. You can get their brands taken off of various internet platforms based on your trademark registration. You can oppose their trademark applications. You can cancel their trademark registrations. You can sue them for trademark infringement, and and much more. The option you choose will depend on the strategy that you prepare and execute with your attorney's advice. And I do mean with your attorney's advice. Responding to trademark infringement is not the kind of thing that you want to DIY because, like I said earlier, things can go left very quickly, mistakes cannot easily be fixed, and you might find yourself in a situation where you have done something that actually is going to hurt you in the long run. The next way to plug up holes in your business that your trademark rights can just slip right through is to make sure that you are using your trademarks properly. Notice my emphasis on the word properly because it is possible to use your trademarks improperly, and in doing so, weaken your trademark rights. So, what are some key considerations when it comes to proper trademark use? First, you will want to use your trademark exactly as it was applied for and registered. Not using your trademarks exactly as they appear on the registration could lead to someone claiming down the line that you have abandoned your registered trademark and therefore should not have protection for that trademark. So if you want to change your trademark or make modifications to it, it can be a good idea to apply for additional trademark registrations. You can continue using your old trademark registrations until the new one is approved and then stop using your old one, or you can use and register multiple variations of the same trademark at the same time. Be sure to train your team members on the right way to use your trademarks consistently. Having a brand guide can be really useful for this kind of training. Second, be sure to publicly notify everyone of your trademark rights every chance you get. You can do this by using that circle R symbol or just posting a statement in connection with your trademark that it is a registered trademark of your business. Doing this puts people on notice that you are serious about protecting your trademark rights, and it can discourage people from adopting similar trademarks. Third, avoid using it as a generic term. This means don't let your trademark become synonymous with your products or services themselves. This can lead to genericide, which is when a trademark loses all of its distinctiveness. As an example, if I say, "Get me a Kleenex," I'm using the trademark generically because I am equating the brand Kleenex with the product, facial tissue. To use this trademark properly, I would say, "Get me a Kleenex brand tissue," or "Get me a Kleenex tissue." When I use the trademark this way, I am identifying the trademark as the source of the product rather than putting the trademark on the same level as the product. And this is the kind of thing that you would want to address in your brand guide too, about the proper use of your trademark. The people who purchase your products and services may not use your trademarks that way, but you better make sure that you do, because not doing it can result in what? Losing your trademark rights. All right, leaving trademark use to the side, let's look at the final thing that should be on your trademark to-do list after you get your trademark registration approved. And that final thing is just simply making sure that you keep the registration active. Doing this simply means staying on top of the required maintenance filings with the United States Patent and Trademark Office. Your first filing will be due between the 5th and 6th anniversary of your trademark being registered. And yes, we are looking at the registration date, not the application date. The registration date is the date on which the application was approved. So once you take care of your filing between the 5th and 6th years, you will also need to make another filing between the 9th and 10th years after the registration has been approved. And then you will make these maintenance filings every 10 years after that, indefinitely until forever, because trademark rights can exist for that long as you want to keep the registration active. Because these deadlines are so far apart, you want to make sure that you don't miss them. So you can put them on your own calendar, but the USPTO will always email you to let you know that your filing is due. So be sure to keep your contact information current with the USPTO. But what are you going to include in these filings? Usually you're going to have to include a specimen or proof of use for your trademark. You will also confirm that you are still selling the products and services listed in your trademark registration, or you'll remove the ones that you are no longer selling. And of course, you got to pay the USPTO a filing fee because they want their money. But importantly, for the filing between the 5th and the 6th years, In addition to what I just said, you will also have the ability to make a filing to claim incontestable status for your trademark registration. Incontestable status is a huge, important benefit that you do not want to overlook because it can make it really difficult for someone to try to cancel your trademark registration based on their stronger rights because they began using the trademark earlier than you did. Like I was talking about earlier at the top of the video when I was discussing how trying to stop infringement can backfire. But even trademarks with incontestable status can still be canceled if they are used incorrectly because the rights have been abandoned or because the trademark has become generic. This is why you need to monitor your trademark use and train your people on how to properly use your trademarks. And that's a wrap. Consistent and correct use of your trademark combined with diligent maintenance of your trademark registrations and enforcement and defense of your trademark rights all play a really important role in protecting your brand and maximizing its value. So staying on top of all of these things is a necessity, and getting legal help to meet your obligations is a really smart move. If you like this video, please give it a thumbs up. Be sure to subscribe for new trademark content and turn on notifications so you don't miss when I drop a new video. If you've got questions or thoughts you'd like to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.